Supreme Court decisions, there's a lot of, you're hearing from both sides, that some people think that they were correctly decided, some people think that they've created a lot of uncertainty and were poorly decided. And what I would say to that is, we have hard data now about whether that's the case or not. And there's hard data that shows, I mean, there was a study that studied every single patent eligibility case at the Federal Circuit since the Alice decision. And that found that 85% of decisions by district courts in applying that law were affirmed. If it really was so unpredictable and so uncertain, you would expect that there'd be a lot of variability. Judges don't know what to do, it's a mess, they do their best, and the Federal Circuit doesn't know what to do, it's a mess. You would not expect to see that level of uniformity in the data, but that is what we see. And so I think that data shows that, in fact, after more than a decade of experience, the proof is that it's predictable, it's consistent. In fact, it was one of the most predictable patent law issues that the study looked at.
And Doctor?
So the problem is that purified, which, as John points out, is still in PERA, is the same thing as isolated. So, and in PERA, if I'm quoting it correctly, there are many multiple negatives, like an unmodified gene is now modified if it is purified or enriched. So that means that it becomes patent eligible as soon as you take it out of the human body. I can't practice medicine to look at the genes in a patient when they remain in the patient. So I need to be able to purify or isolate, and if that then makes it patent eligible, that means I will be stopped from doing that by some patent holder on that genetic sequence. cDNA is a little more complicated in that cDNA is copies of messenger RNA, which is made from DNA. So that's I now started talking Greek, sorry. So cDNA is a whole other issue that we can get into if you really want to go there. But I would ask that somehow in PERA, with language that maybe we can provide, the human genome, pathogen genomes, relationships between variants in genes and diseases not be patentable. They can be a building block, as John says, for other patents on top of that. But that way we can use this information for medical practice.
And you fear that as it's written now, it would give patents in an overly broad way that would restrict what you can do with DNA.
Yes.
Actually, we have Senator Hawley coming, and we'll let him ask questions. Senator Hawley, you're coming in the middle of our debate club, but we're gonna come back to you. But a part of what Senator Coons talked about was getting straight to the line. The whole reason that we've had fit-be witnesses and endless work groups is to try and address the legitimate concerns. So we'll come back to that. But for now, because I also want to ask the basic question you all can be thinking about. This is the eligibility phase of the process. I'd like for some people to talk about examples of whether sections 102 and 103 would knock out the patentability, even if it was eligible. So be thinking about that. Senator Hawley.
Thank you very much, Mr. Chairman. Thanks for calling this hearing. Thank you to the witnesses for being here. Dr. Leonard, I wanted to start with you if I could, and I wanted to just ask a question or two about prescription drug prices in the United States. Everybody I know, every Missourian that I know, heck, everybody from any state that I know is struggling to afford prescription drug prices in this country. It seems that they do nothing but go up and up and up. Drug prices in the United States are significantly higher than our closest peer nations. I think we've got a poster here that I'm going to put up, an analysis from the RAND Corporation back in 2024 comparing U.S. brand name drugs, prescription drugs, to those of other two countries. 32 countries were compared in the study. We've got here Canada, France, Germany, Italy, Japan, Mexico, and the United Kingdom. And it shows how much more the United States, our prescription drug prices, how much our prescription drugs cost on average than the prescription drugs in those countries. In Canada, our prescription drugs are 324% more than the Canadians, 445% more than what the French pay, 464% more than Japan, and on average in this 32-country index, 422% more. There's the cost of insulin. The average United States insulin manufacturer price per unit is $98.70. In Australia, it's $6.94. It's $12 in Canada. And in the UK, it's $7.52. Now, this just seems to me totally outrageous and totally unaffordable for every American. Somebody is getting rich off of this, and it's certainly not the American people. So Senator Welch and I have introduced a bill called the Fair Prescription Drug Prices for Americans Act that would stop Big Pharma from selling drugs in the United States at a higher price than the international average. And there would be stiff penalties for those who violate that rule. My question to you is, do you have a view on legislation like that, or what we're going to do about the cost of prescription drugs more broadly? I think that this is a crisis that the American people cannot afford to go on any longer, and it's time that we took action on it. I'm just curious, in your professional opinion, what your thoughts are on this.
Well, this is totally off the topic, other than prescription drugs are usually patented. I think it goes back to the basic problem in the United States. If you look at any of those other countries, they have national health care. I'll stop.
Anybody else want to comment on this?
Sure. Thank you. I don't disagree with what you put up at all. We care a lot at the Alliance for Aging Research about affordability, particularly for older adults. And I would love to meet with you and talk about the work that we've previously done on affordability and prescription drugs. Patents generally aren't the reason that prescription drugs cost so much. In fact, without them, a lot of treatments wouldn't exist. So we wouldn't really have anything to argue about if we didn't have the drugs themselves. Patents really encourage investment in new therapies and improvements in existing ones. So happy to talk to you about affordability issues.
But don't you think that we can find a way to protect our patent system, which I'm all for doing, provided that it's not gamed any further by the pharma companies to keep prices high? And let's be clear, the pharma companies are absolutely gaming the patent system in order to keep prices high. I mean, I think there's no doubt about that. You can't look at these numbers and not think that our pharma companies are not ripping off consumers in the United States of America.
Good night.
And maybe that may not be the square topic of this hearing, but I can tell you what, it's what the American people care most about.
Yep.
They care about this right here. They cannot afford their prescription drugs. And until this Congress does something to bring down the cost of prescription drugs, we're just whistling Dixie. I mean, the American people don't care about that. They care about what are you going to do to make health care cheaper in this country.
That's right.
And so far, this Congress has done precisely zero to make health care cheaper in the United States of America, and nothing to bring down the cost of prescription drugs. Yes, sir.